Hello everyone and welcome back. In this video, I want to educate you about the Marchman Act and specifically who can file this thing. Now, many years ago, before they made one of the multiple changes they've made to the Marchman Act, it had to be three people. Three people had to come forward and say, oh, this person needs help, they need to go to treatment. These days, it's only one. Well, who is that one single person? And when I say that, it doesn't mean to say that you can't have more than one. I mean, frequently, if it's mum and dad who are petitioners, they could be co-petitioners, right? Better to have mum and dad as opposed to just mum or just dad. But in theory, it's only one person. And the section of the Marchman Act statute that you can look up is 397.68112. And I'm going to look at subsection 1. If the respondent is an adult, because it's different if it's a child, a petition for involuntary treatment services may be filed by the respondent's spouse. Sometimes we get husband versus wife or wife versus husband, or legal guardian, any relative, a service provider, or an adult who has direct personal knowledge of the respondent's substance abuse impairment and his or her prior course of assessment and treatment. If the respondent is a minor, now I'm looking at subsection 2, a petition for involuntary treatment services may be filed by a parent, legal guardian, or service provider. Let's ignore the service provider for a second because I don't want to confuse you. But if it's a child, it's got to be the parent or the legal guardian. If it's an adult, it can be one person with direct personal knowledge. And I emphasize direct personal knowledge because a lot of the time, families will call us and they'll say, well, my loved one, right, my adult child, my adult son, my adult daughter is using substances. Well, how do you know that? Well, the girlfriend, the boyfriend, the significant other told me they are using. Great. Is that person willing to come to court and testify? No, they don't want to get involved, but they've been calling me to tell me this is happening. Well, we have a problem now. And the problem is of an evidentiary nature. And what I mean by that is there's no direct personal knowledge. In other words, if mum and dad have not seen adult child for weeks, months, and they're hearing this from a third party, and that third party is not willing to come into court and testify, then there's no direct personal knowledge. And this is not a good case. It's probably one that we wouldn't take. Now, I can't speak for the rest of the legal community, but I'm going to tell you that in my office, this case is probably going to get rejected. And it's not because we don't want to help. It's because I'm pretty sure, just by speaking to the parents, that if we file this case, first of all, they don't not have direct personal knowledge. So they have to be telling the court what somebody else said in the assessment petition, or the request for assessment relief, I should say. And that's a problem. But let's say we get into court and now we're at the treatment services portion, or even maybe a hearing on an assessment petition, and the judge finds out they don't know from direct personal knowledge. You know what's going to happen? Dismissed. The case is going to get dismissed, and the lawyer is probably going to get, and deservedly so, a good dressing down by the judge, who's going to say, counsel, your client does not have direct personal knowledge of their loved one's substance abuse impairment. And I presume that you knew that before you came into court, because if you didn't prepare for the hearing. And so it's a problem. So the reason I'm sharing this with you is that if you are a family who's got a loved one that you suspect is using, you need to know that for sure. And it can't be based on what somebody else is telling you unless that person is also willing to come into court and testify and tell the court, because they're the ones with direct personal knowledge. So I think that's an important thing to know, which is why I tell parents, be nosy about what's going on with your children, right? What have you seen? What have they told you? Because if they've admitted it to you, great, that's admissible, right? That's not a third party telling you, that's the respondent, your loved one, telling you they're using. And obviously if there's evidence to support that, their behavior, you found, paraphernalia in the house, things of that nature, and maybe we even have a third party like the significant other who's willing to come into court. Oh, that's a great case. That's one I want to take. I think we have a winner on our hands. But important to know, direct personal knowledge. Anyway, with that said, If you have any comments or questions, please post them. I read all of them. I typically respond within about 24 hours. And if you could, I'd love a thumbs up. Please subscribe to the channel. And with that said, I will see you in the next video. Take care. Bye-bye.